And they can't make those, you couldn't make those in a closing argument. They couldn't get up there and say those things for a reason.
Defense counsel said that you will hear Kouri Richins telling her family that she purchased pain pills for Eric at his request. You did not hear that, although she did write it in the Walk the Dog letter.
You couldn't make those in a closing argument. They couldn't get up there and say those things.
Walk the dog. There's a lot to unpack in this. But right now, let's unpack the fact that Kouri Richins says Eric gets pain pills and fentanyl from Mexico.
You couldn't make those in a closing argument.
And indeed, later in the Walk the Dog letter, admits to asking Carmen for fentanyl.
They couldn't get up there and say those things.
Beginning the night she murdered him, all the way through the Walk the Dog letter.
For a reason.
Right. All right, let's begin with the motion to dismiss. Who's arguing that one?
I am.
Ms. Lazaro, why don't we talk about that for a second?
Okay.
Where would you like me to go on that?
Well, I prepared an argument.
Go ahead.
I'm happy to address questions, or if you want to stop me midpoint and ask questions, however the court wants to proceed. But
Perhaps I can begin with a threshold question, if you don't mind.
Yeah.
In order to grant the motion, I have to make a finding that some kind of conduct by the state's counsel rose to the level of a denial of due process or the denial of a right to a fair trial, right?
Correct.
A lot of that conduct you cite in your motion has to do with letters and filings made after a search of Ms. Richins' cell and statements or allegations regarding witness tampering or the danger thereof. Well, what if they just amended the information and brought charges for witness tampering based upon the same searches and the same evidence? I use evidence loosely. I'm not suggesting that anything's admissible or wouldn't be subject to a motion to suppress. We'd be right where we are right now, but I don't think that would be misconduct.
I don't think so either, and here's why. If they had formally charged her, she would be given due process rights as it relates to the alleged witness tampering, right? We would be able to cross-examine people. She would get a trial, we'd be able to present witnesses, we'd have arguments whether or not evidence was going to be admissible or inadmissible. The problem with the way the state has characterized this in their briefing is the fact that they have definitively said she's guilty of it without being afforded any of those. And I think being charged with something is different than the state saying she witnessed tampered. This isn't the first time she witnessed tampered. This is further evidence of witness tampering, all of those things. And then they go on to say, you know, not only did she witness tamper, but because she witnessed tampered because she's guilty of murder. Like her witness tampering is a consciousness of guilt. And I can pull it out of the briefing. We prepared it in slides, but that's the problem, and that's the violations of rules 3.4, 3.6. And the ADA standards is you can allege some through a filing or through a criminal complaint, right? She's here today because the state's alleged that she committed a number of crimes.
Sure.
Right? And she's going to get her preliminary hearing, and we're going to go through this entire process before we get to say she's guilty or not guilty. And the problem with the state's characterization over and over and over again, and in fact it got progressively worse or progressively more definitive in their statements that she is guilty of witness tampering, and that's the narrative that the media has picked up. And I think that's the violation of the rule, not, you know, if they had charged her with it, you're right, we would still have to deal with it. And perhaps there would be some press surrounding it. But we would also then have the opportunity to refute that or go through due process rights. But by just saying she was guilty of it, and by saying she was guilty of it is bad. By saying she witnessed tampered is a consciousness of her guilt is worse. By saying she administered the fatal dose of fentanyl is worse.
So
And they're tying all of this together.
a lot of that water went under the bridge as of the detention hearing. That is their theory of the case, that there was a financial motive. There was poisoning, caused the death
Right.
of her spouse. I mean, that's the case. Then we have requests for things like don't let her talk to certain individuals because, and then once we get into because, their justification for the request is we're concerned that she's trying to alter their testimony at a future trial. Stated broadly, everything I just described is part and parcel of lots of criminal cases.
Right, except for the fact that they go further to say, they have a theory, right? It's in the probable cause statement, it came out in testimony at the detention hearing, you're right. That happens in every single criminal case, and we can cross-examine people and weigh the credibility of witnesses as we go through, okay? The problem is in their briefing, they dispel or they characterize the defendant's alternative theory or perhaps a potential theory of the defense as a false narrative, that it's a lie, okay?
Sure.
Which completely diminishes the credibility of anything we say. And then they've gone on to say, and all of her witnesses are lying, and she's telling her witnesses to lie. So now we're in a position where anybody we put up there, you know, a jury pool is going to say, well, I mean, she witnessed tampered, so obviously these people are lying. And the state's already said that anything she says is a false narrative because it doesn't fit their theory. That's a problem, and the rules specifically prohibit the state from commenting on the theory of the case, or on alternative theories of the case, or on the credibility of witnesses. And
Trying to determine where the line between permissible advocacy and permissible communications that would
well,
irreparably damage the jury pool. I acknowledge that however long jury selection was going to be at the end of the detention hearing, it seems like it's 3 times longer now. I'm with you. I got it. But why can't we, through a combination of lengthy and careful jury selection and instructions to whatever jury gets selected, mitigate the harms that you're describing?
I'm going to answer this in 2 ways.
Sure.
Okay, the first one is, I want to address first is the rules are clear about what they can and can't do. And the rules are clear about prosecutors in particular, what they can and can't do. And they have a heightened duty. And there's case law out there that specifically says they have this heightened duty because things that come from the government come with more indicia of credibility, right? If the government's saying she's a liar and the witnesses are liars, and any theory she has of the case is a false narrative because it doesn't fit theirs, that's a violation of the rules, like period, I think. Or at least that's our position, is they have clearly violated the rules in doing that. And in going so far as to make statements about her guilt. There's been a violation of the rules. I think what you're getting to is a potential remedy, and I think the prejudicial effect is that this is everywhere. We pulled, I mean.
But it was everywhere long before this.
It was, but it was everywhere before the state started making these comments. It was going to be everywhere. I don't think, I mean, I'm not gonna sit here and say that, oh, you know, this wouldn't have happened, or there wouldn't have been news stories, sure. There would have been news stories about this case no matter what we did, and I think that's a given. The problem is now these news stories have adopted the state's interpretation of the letter. And the news stories have run with.
I mean, I have assiduously tried to avoid news coverage of the case
Right.
just to make sure that my consideration of it wasn't polluted by any inaccuracies in the popular media. But even I've bumped into the cover of People magazine, which seems to indicate or have at one time been providing a counter narrative that seems to be provided by the defense side of the media. I mean,
I think there
why
is
isn't this a case of both sides airing their competing narratives to the fullest extent they believe is permissible under the rules.
I think you can advocate, but I think it has to be within the rules. And when you go so far as to essentially say she's guilty of witness tampering, and because she witness tampered, she committed murder, and the Today Show pulls a snippet and puts it by her face that says she, she told these people to lie about whatever it is, that's a problem. And I think that goes a step too far. Yes, we can all effectively advocate. We're going to do it through briefing throughout this case, I'm sure. But I think there's a line in what you can say, and I think the rules are very clear on it. And when the state starts making conclusory statements about her guilt, about the credibility of her witnesses, about her credibility, about my credibility, I don't think, and then the narrative becomes, and the comments that we pulled are, she's guilty, she's, why are we even doing this? This is just a box to be checked. Like, these are local comments. And yeah, you're probably gonna get some of those, but the state has taken it a step too far. And the other thing I want to address is there was an alternative method to this. And in the ABA comments, this goes to the second part of your question, 2 questions ago, regarding, if they think she witness tampered, can they bring a motion and ask the court for relief? The answer is yes. Okay, I think we can agree on that. The problem is in the way they characterized it and the statements they made in their brief. The second problem is it should have been, our position is it should have been done differently. And the ABA comments speak directly to it, and it's 8-2 point, one second, I'm gonna get there. I can only remember so many numbers. Point 1, and what it says is, a lawyer participating in a criminal matter should not place statements or evidence into the court record or into a document that is deemed an open record under applicable law solely for the purpose of circumventing this standard. If the lawyer has reason to believe that the public release of the record or document would create a substantial probability of harm to the fairness of a trial or other overriding interests, the lawyer should consider seeking a sealing order pursuant to standards.
Pause there for a minute. In order for a violation of the rules to be material, it has to have caused irreparable prejudice such that due process is violated, she can't get for trial. So let's stay focused there. I'm just not sure we're at that point, given the amount of publicity that existed beforehand, what the comments probably said before all of this, the availability of other measures. Dismissal is the ultimate sanction. And correct me if I'm wrong, I don't think you cited a case in which the case was dismissed prior to trial for this kind of conduct rather than during trial. Am I right about that?
Or after.
Okay.
Correct. Candidly, I did not find a case that stated that.
Can we just acknowledge
Yeah.
that during trial, the options are so limited. The jury's already in a box. We can't re-impanel.
Right.
Jeopardy's attached.
Right. I think that is a different scenario. I think some of the cases, though, that came back on appeal, right? Like, it didn't get dismissed during trial. The conduct occurred, prior to trial. And those cases came back on appeal, for a new trial.
Those were investment kickback, side deal, right? Not pre-trial publicity cases. Am I right about that?
Correct.
Okay.
So I do think it's nuanced, or I think it's difficult in these cases. I think we can all acknowledge that. But there is a process in place to ensure we can do the best we can, to take care that we all do the best we can, not to violate any of her rights to a fair trial. And the state, in their assertions and the statements they have made, have not done that. And the prejudice is you can't we can't undo that, okay? This letter is out there forever, right? Whether it's ultimately admissible at trial, doesn't matter at this
It
point.
matters a little bit, doesn't it? Because if it were to come
I mean, I'm gonna
to
argue
trial-
it matters, because I'll probably move to most of it to suppress it, but,
Well, sure,
Right.
so I mean, but, and I'm not expressing an opinion one way or the other
Right.
about any kind of motion or in that regard, but imagine the letter came in at trial. Any pretrial prejudice is now mooted, it's in. The actual jurors have seen it and heard it.
the problem is the statements the state has made during the pretrial phase, right? The statements that they have interpreted, this letter's open to multiple interpretations,
Sure.
right? And yes, we can get to that through cross-examination and
If it comes
it,
in.
or, yeah, at trial.
Right.
The problem is that there is local, national, global media where the state has interpreted the letter in the way they want and has put out to the world and all of our potential jurors that Kouri's lying, that her witnesses are lying, that her theory is false, that that's the problem. The problem is their statements and the way they've interpreted it, and the prejudice to her is, you can't undo that. I mean, sure, we can probably ask people, questions in voir dire, but I don't think that's sufficient given the egregiousness of the statements. If it had just been, the way it should, in my opinion, the way it should have been done, or the state's, or the defense's assertion is they could have moved the court for a motion for a no contact order. They could have filed it under seal. They could have filed the letter under seal. We could have had this argument or in a way that wasn't the state saying that she witness tampered. It wasn't the state saying that her witnesses lied. It wasn't the state saying she's guilty of murder. Those are the problems, and those aren't going to go away. Forever, there's going to be this issue that the states said that, and they can't do that. And if the courts, and I granted, dismissal is the ultimate remedy, right? But there are alternatives. I don't think any voir dire is going to cure this issue, given the egregiousness of the statement.
So I looked at the defense's proposed alternative remedies. I'm not prejudging a motion to change venue, but you haven't provided a basis to change venue. Yet the dynamics that we're talking about, as far as I can tell, exist statewide, nationwide. This case was covered by a BBC. I don't know that you will find a jurisdiction that is certainly not the state of Utah that is going to be materially different than Summit County in terms of its saturation of media coverage of this case.
Correct. I think there will be other grounds, and that motion will come. We're
Okay.
fairly early in
All right.
the process of this, so I do anticipate moving for a change of venue. Based on I agree. Unless we're going to some tribal land in Ghana, we're probably not finding people where it hasn't touched. But I think there are other issues that we will bring to the court's attention that we believe would support a change of venue. We don't need to get into that today, but I do anticipate that will be coming.
Then we have disqualification in the Summit County Attorney's Office, and I'm not sure why that follows. Here, at this point, aren't they the most sensitized to the issues and the permissible bounds of what they can and can't say, rather than somebody else?
Wait, say that again.
Well, they've been involved, they're going to be subject to whatever ruling they make. I don't understand why disqualification of that office based upon public comments, conduct they've taken in prosecuting case-making motions, rather than extrajudicial things like those things that exist in other cases that were discussed in the briefing of embezzlement, bribes, that kind of conduct. Here, if you're right that they violated some ethical rules, well, now they know. And I would remain confident they wouldn't do it again.
I don't think that cures the problem.
Tell me why though on a going forward basis. What is it about the continued involvement of the Summit County Attorney's Office on a going forward basis that would be prejudicial to Ms. Richins?
I think if the court takes no action against the Summit County Attorney's Office, they're sanctioning what they said. And I think that adds additional credence to their statements. And I think that's a problem. Further, they've been involved in the investigation. I'm gonna allow me a little more, thank you. So, when they began investigating this case, I was having communication with the Summit County Attorney's Office. So they've been involved since the very beginning of this investigation and throughout it. And so they are intimately intertwined in the entire investigation as it went forward. Further, then they've said that this is our theory, there's no other theory, and the defense theory's gotta be a lie because it doesn't fit with our narrative of facts, right? The problem is, you know, there's an insinuation that perhaps they drove the investigation and this is where it ended up. And if it's.
Tell me what you mean by that.
Well, they made the ultimate conclusion that she's guilty in their briefing,
Okay.
okay? And they were involved with the sheriff's office throughout the entire investigation. And they're saying that, you know, any alternative theory, say we, you know, go out and investigate and have investigators working and come forth with additional things or alternative theories or whatever, they've already said that can't be true because it's a lie.
Okay.
And because they drove the investigation or they were so involved in the investigation, I don't, you know, maybe they can go look for any. I think the implications of.
That's a great closing argument regarding Ms. Richins getting railroaded, but I'm not sure that justifies by itself
I think
disqualifying the Summit County Attorney's Office.
I think in order to fix the narrative that the state has put out there needs to be drastic measures. And one of those could be, or should be, you messed up and you're off the case.
I understand that argument.
I mean, I think that is the only, the only way to correct the violations that we've alleged is to say, you know, that they made mistakes, they violated the rules, and therefore they're not on the case. I think that puts us back a little bit to center where now we can go forward and we can present theories and there's a message out there that says, look, they shouldn't have made those statements, they can't make those statements, and by disqualifying them, the office as a whole, I think it sends a message to potential jurors that that's incorrect. And that there's
Isn't that
potential.
problematic as well, though? Or we'd be sending a message, I mean, we'd have to exclude all the jurors that had any sense of that, that were going to draw any conclusions upon that. We need potential jurors that were agnostic about that, wouldn't we?
Meaning,
Meaning they didn't have an opinion one way or the other regarding the motives or conduct of any of the participants.
right, but there's still, I don't think without proper remedies from the court, it restores Kouri's right to a fair trial.
Okay.
I mean, at the end of the day, we can't, doing nothing essentially just adds credence to what they said, and she's in a place now where, you know, we can't call these witnesses, I mean, we're gonna call witnesses, but, you know, we're on the presupposed motion, or assumption that, the world is taken, that they're liars, because that's what the state said. And they can't make those, you couldn't make those in a closing argument. They couldn't get up there and say those things for a reason, right? So you should be able to say it now.
Well, I mean, let's be more specific about that. If they wanted to get up and say that, for example, Ms. Richins testified to X, Y, and Z, I think the state would be able to properly say, listen, compare X, Y, and Z to evidence A, B, and C. The inconsistency shows that X, Y, and Z is a false narrative. That is proper closing argument.
Right, but it'd be based on evidence,
Fair enough.
right?
Yeah.
And you could, that's what you advocate in closing arguments. You can say, we presented this, the jury gets to weigh the credibility of everybody's witnesses, including the defendant, and make their own determination. They've circumvented that entire process by saying it now. They predispositioned everybody to look at these people through a lens that they're lying, to look at Kouri through a lens that she's lying, to look at Kouri through a lens that she is trying to get people to lie for her, to look at counsel, frankly, through a lens that I'm doing improper, I'm doing nefarious or criminal acts, is what they've alleged. So that's the problem. They have essentially hit every single part of the rule that you're not supposed to violate. And the comment to 3.6 lays out things that are materially prejudicial. So I think that answers that question where they're making these statements now. 3.6 in the comments specifically says these things are materially prejudicial. And those are the things that they've done here.
I understand your position. It won't be the last time you get to talk. Let me hear from the state. Was there anything else you wanted to put on the record in the first place?
No. Well,
Mr. Pleasant.
Good afternoon, Your Honor.
State's briefing was a little general in terms of we haven't done anything wrong, there's no prejudice, let's just move on. Address Ms. Lazaro's argument that the things that the state said in its briefing related to the walk the dog letter are not the types of things that the state would be allowed to say in closing argument.
Your Honor, they are the things the state would be allowed to say in closing argument. It is fair argument, fair advocacy based on facts in the record to date. And that's an important point here, is that consistent with First Amendment jurisprudence on public access, consistent with the court's rulings on public access, these are public debates. These are the debates where the state makes its case in a filing, and the defense has an opportunity to rebut that case in the filing. They just rebutted it, not only in their prior filings, but right here, right now at this podium. And that is fair litigation. That is how cases are litigated in the criminal courts throughout Utah every single day.
Would you acknowledge that during jury selection, we will need to identify jurors that have knowledge of a whole long list of things, including the briefing and media coverage regarding the walk the dog letter and the manila envelope and any number of other things?
Yes, Your Honor. Undoubtedly, the court and the parties will select a fair and impartial jury. That will take longer than normal. that will take a jury pool larger than normal, an enlarged questionnaire, expansive voir dire. But there are people in Summit County who are not following this case, at least a dozen or so. And there are people, who we can see as very impartial. Summit County Court set a jury in one of the Paltrow matter that received tremendous publicity. The court was right to note that much of this publicity is both national and international. More so probably than Summit County. I can think of two pending cases before this court, one civil, another criminal, that are receiving as much local ink as this case. And the court will see Summit County juries in those cases as well. As it relates to the walk the dog letter, and kind of this instant discussion we're having, the Algiers case that I remember was the state or the defense cites in its briefings, in dicta makes, I think, a pertinent note that the publicity at issue in the prosecutorial misconduct retrial motion was kind of a drop in the bucket in the overall publicity of the case received over the arc of time.
Right.
That's where we are here as well.
Okay. Anything else I can say on this motion? We have plenty of other ground to cover.
Your Honor, if your questions are answered, I will sit down.
All right, thank you.
Thank you, sir.
This is hard.
There are a couple of things I'd like to address.
Please.
With so engaging. The first point I'd like to bring up, and we addressed it in our briefing, is the state in their response briefing to this doesn't address really prejudice, as the court just noted. They don't address it at all. That they're, essentially, what they say is it maybe doesn't matter, that this is out there and so be it. The next thing, I think it's important to look at the statements. The state is saying that they could say these things in trial. They could say these things, perhaps some of them, if they're supported by evidence in closing argument. What they can't say, and I think I'll just pull out a few of the ones that I think are particularly problematic, is, they first say that the court needs a no contact order to prevent the defendant from further engaging in witness tampering. Essentially implying that she's witness tampered before.
Right, but I come back to the hypothetical if they had just charged her.
But they haven't, that's the problem.
I know, but isn't that better for her?
Well, yeah, I don't want any more charges, I agree with you.
But isn't it a proper exercise of prosecutorial discretion to say, that is a distraction to prove that lesser charge? We're gonna focus on the top level charges that are in the information.
Absolutely, absolutely. And I don't.
So the only reason I raise that is to say, in that alternative universe that I am describing my hypothetical, the information, the preliminary hearing, all that stuff would be transmitting the message, she's a witness tamperer. That is not different than we have here. It might be worse.
It might be, but it might not be, and here's why. The state concedes in their brief that they didn't have evidence that she ever passed the letter or witness tampered, right? So we would actually get to stand up here and say or cross-examine people to essentially prove that that wasn't true.
Well, that's probably
So,
not to
and I don't think that
why I'm
matters.
disinclined to prevent her from talking to her mother and her brother.
But the issue is that they have just declared that she's guilty of it, right? Instead of.
Is there anybody in the world that thinks the state of Utah doesn't believe she's guilty of the crimes for which she's been charged?
Is there anybody in the state of Utah? Well, I hope so.
Well, I guess no, not that they believe personally, but that does anybody out there think the state is just doing this as theater? I mean, the state's position from the beginning is she's guilty.
Right.
I don't think they've been unclear about that.
No, but the problem is that they've used, the way they've drawn the inference between witness tampering and the ultimate decision that a jury is gonna make in this case after it hears evidence is that because she witness tampered, it's a consciousness of guilt. You know, she induced people to lie because she's guilty, right?
Isn't that similar to some of the arguments that we heard and on which I relied during the detention hearing regarding the internet searches? Consciousness of guilt, trying to hide conduct. I guess what I'm saying is that why is making arguments regarding a particular piece of evidence, admissible or otherwise, showing consciousness of guilt? Why isn't that a proper conduct rather than improper conduct, whether it gets media attention or not?
Because the rules specifically say that they can't comment on her guilt. The rules specifically say you can't comment on the credibility of her witnesses. The rules specifically, I mean, it's clear in the rules, it's very clear in the rules what you can't do, and that's what they've done here.
But you're not suggesting that the rules prohibit, as a matter of law, making an argument regarding consciousness of guilt in a pretrial finding.
I think when you tie it to the ultimate, I think it depends on the context, right? I think you could use this phrase, consciousness of guilt, in a number of different ways that doesn't say she's guilty of witness tampering, we're telling you she's guilty of witness tampering, and because she's guilty of witness tampering, she's doing it because she's guilty of murder. And that's what you can't say. You can't go that far. Yes, there are probably a number of ways you could argue that in different ways that may not violate the rules. But the way they've done it here violates the rules because they're specifically commenting on her guilt in this case. The other thing I'd like to address is the ABA standards essentially say there's different ways to do it. Like you could have done it under seal. This wouldn't have been an issue. She spent a vast amount of money. Taxpayers have probably spent a vast amount of money and time on this issue where we're not working, it's limiting our ability to work on other things. We're doing this. Ultimately, this rests on, or what's alleged violated jail procedure policy. They make that determination, okay? The jail has internal remedies to deal with that. And the jail has decided that she recently violated one of those, and they have prohibited her from contacting her mother. So there were other ways to accomplish this goal without creating a media narrative for the state's position on her guilt and the credibility of her witnesses. And I just want to turn the court to the Hensley case. We relied on it in our briefing.
Is that the Fifth Circuit case?
It's a Fifth Circuit case.
That was during trial though, right?
It was.
Okay.
And I get that sometimes it's different. It can be different during trial because you didn't panel the jury. Those are the people who are sitting in it, right? I think that is different.
By implication, no other available alternatives to mitigate potential prejudice.
Correct. Okay. But it's still, and maybe these don't get litigated, I don't know. I mean, I don't know the answer to that. Maybe, I don't know how many people, how many arguments are had. If this were a case without a lot of press, right? If this were normal course, like my 60 other whatever cases I have, right? That are going through the courts, you know, sure, we litigate things on the record, but nobody's looking at the record, right? It's not getting broadcast out to potential jurors. And so when you look at those types of cases in a normal course, it may not be problematic. I mean, it may still be a violation, but the prejudice may not be as grave as it is in this case. Because, you know, nobody would see it, right? The jurors, you know, I panel juries all the time that have never heard of my clients and have no clue about anything that happened, and you know, they go about the normal course of business, and so the only thing that's brought to their attention are the things that are said in trial. And so that's why I think we see most of the case law come from that, because that's how the majority of the cases go. This case is different because this case has so much publicity. Greater care should be taken to ensure we're not tainting a jury pool, to ensure we're not saying the things in pretrial matters that we couldn't say at trial, because the effect is the same. We're potentially causing the same harm that would happen in those other cases to a jury when it's broadcast to the world, where we have, you know, jurors that have likely heard of it. And I don't think that the extent that the state has gone to in this case can be remedied short of, I mean, obviously we're here asking for a dismissal, but alternatively, without grave sanctions against the state. And we suggest that they be removed and to start over or continue forward, that's what I should say, with a clean slate, in order to, you know, put some order back in and, you know, go back and ensure her fairness, her right to a fair trial. These premises aren't lip service. I mean, this is essentially the most important thing we can be arguing at this point, is whether or not we can ensure that she gets a fair trial. I think that ultimately is the most important thing in a criminal case. It's, you know, the lofty reason a lot of us started doing this in the beginning, because we're going to be a champion for the rules. But and I don't mean to make light of that. I think that's true for most of us who do this. But it is the most important thing. And so it can't be just, well, as the state says, like, too bad it's out there, we're just going to keep going, it's fine. It's not fine. It's not fine because they violated the rules, and the result of that is worldwide prejudice and a world that thinks that her liars and her witnesses and our counsel, you know, are going to misrepresent things to them or lie to them. And that's a hard thing to remedy.
I understand your position.
Thank you.
Thank you. The issue before the court is defendant's motion to dismiss due to prosecutorial misconduct. The gravamen of defendant's motion is that due to conduct by the Summit County Attorney's Office, defendant has been denied due process and her right to a fair trial. Specifically, defendant asserts that statements made by the Summit County Attorney's Office in briefing related to the walk the dog letter briefing related to the Summit County Attorney's Office request for further limitations on Ms. Richins' ability to speak with her family members, have included statements that violate Rules 3.4 and 3.8 of the model and Utah Rules of Professional Conduct. Those statements include things like, quote, defendant is engaging in witness tampering or needs to be prevented from further engaging in witness tampering. The motion for no contact was based on the defendant's witness tampering and the breach of jail security procedures. The walk the dog letter illustrates the defendant's consciousness of guilt. With respect to certain explanations made by the defense for certain actions, that no such link exists in the evidence, that defendant concocts a false narrative, that defendant's own handwriting, she attempts to induce her brother to testify falsely, that she is facilitating witness tampering and supporting a false factual narrative, that she is giving her mother instructions to induce her brother to testify falsely, that this may indeed not be the first time the defendant witness tampered, in that defendant is making a frantic, dishonest attempt to explain how fentanyl came to be involved in this case. When viewed in isolation, these comments raise concern that they would cause undue prejudice by tainting the view of potential jurors in Summit County, the state of Utah, nationally, internationally, regarding Ms. Richins, her credibility, the credibility of her counsel, and her ability to defend herself in a fair jury trial. But when read in context, and given how these comments are anchored to evidence in the record and motions made by the parties, these comments are within the bounds of professional conduct under Rules 3.4 and 3.8. These are examples of permissible advocacy on behalf of the state in support of its request for things like further limitations on Ms. Richins' ability to discuss, contact, correspond with certain family members, and also in response to arguments made by defense counsel related to other litigation topics. Moreover, before this issue arose relatively recently, this case had already received an inordinate amount of media attention, an amount so large that it is frankly not in the interest of justice. But the First Amendment works the way it works, and I can't prevent that. What the court can do and require counsel for the defense and the state to engage in is measures to mitigate any potential harm from publicity regarding the advocacy in this case on a going forward basis. And that would include careful, lengthy, and detailed voir dire jury selection. We will need to identify jurors that do not have any preconceived notions of the subject matter of this case or any of the people involved in it, parties, counsel, witnesses, etc. That may be a lengthy task, but it was made lengthy long before this issue arose, given the pre-existing publicity regarding this case. Moreover, these arguments would have been appropriate and without objection, the court expects, had Ms. Richins actually been charged with witness tampering. that situation, the court would be making determinations about whether or not there was probable cause for the charge, and there was probable cause to bind her over for trial, and these very same arguments regarding potential consciousness of guilt and materiality of the letter would have been made and would have been wholly appropriate. Here, based upon the briefing currently before it, the court simply isn't persuaded that the conduct of the Summit County Attorney's Office violates Rules 3.4 or 3.8, or has caused Ms. Richins a denial of due process or a denial of a right to a fair trial. The court is confident that it can preside over a sufficient or dire process to ensure that Ms. Richins does in fact receive a fair trial. For these reasons, the defendant's motion to dismiss due to prosecutorial misconduct is denied in full. All right. Any questions, Ms. Lazaro? Mr. Blow?
No, yeah.
All right. Let's move on from there. Let's go to the no contact order. The motion for no contact order. Mr. Bloodworth, you probably had this since when we last discussed this, but I am disinclined to limit Ms. Richins' ability to speak to her mother and brother for several practical reasons. First, I've got to swim pretty hard upstream against the First Amendment to enter that kind of work. Second, there are several non-criminal case related issues that she probably needs to be talking to her mother and brother about, and those are implicated in many of the motions and issues that are being raised in the civil cases, the estate case and the wrongful death case. And so if I gag her in this criminal case, I'm prejudicing her in those cases. Moreover, the cat's out of the bag. You know exactly what she's saying to them. All her jail calls are recorded, you have the letter, you're asking for the narrative. I don't understand what the prejudice is here.
Your Honor, let me take a second crack at it, and we'll, in the course of this explanation, get to the prejudice. Your Honor, in a sense, the court has its hands on a dial. And if it turns the dial in one direction, it can amplify the protection against witness tampering in this case. If it turns the dial...
Assuming any has occurred, right?
I'm going forward.
Okay, fair enough.
Going forward.
Yeah.
If the court were to rotate the dial in the other direction, it could more narrowly tailor the prior restraints. And they're correlated, right? So if you amplify the protection, you're going to have a much broader prior restraint. And so when the state first asked for the no contact order, a lot of water under the bridge since then. When the state first asked for the no contact order, it asked for a lot of protection against future witness tampering, which also meant that prior restraint wasn't very narrow. I think we're at a point now, having all learned a little bit over briefing and argument before today, including today. Based on where we stand now, the state will kind of adjust the dial, accept some risk of future witness tampering in order to more narrowly tailor the prior restraint. And I recommend, to accomplish all of that, to include the necessary communication you referenced in your question. I think a more reasonable and appropriate order reads something like this: that the defendant shall have no contact with her mother, Lisa, and her brother, Ronnie, regarding the criminal case outside the presence of counsel. That would allow any necessary contact to prepare her defense. That would allow, in fact, necessary conduct with her mother and brother to prepare her defense, but it would place counsel there to ensure that it was just preparing her defense. Then the order would read, any or all contact outside the presence of counsel will be either through an in-person visit at the jail or through the jail's home wave applications, text. And I say this because there is a monitoring component involved. The state is having to monitor the defendant to ensure putting forward their witness testimony. And the state thinks restriction on in-person and texting allows monitoring kind of without gaps. We get into monitoring hours of phone calls. There are gaps.
Status quo right now, a defendant in Summit County Jail is given notification when they make a phone call that it may be recorded, right?
Yes, Your Honor.
In-person meetings, are they notified that those may be recorded?
Yes, Your Honor. They are audio and visually recorded. The inmate and visitor are both notified.
And status quo, the inmate can't pass anything to a visitor, correct? Outside of counsel. And we'll get into that in a different motion, but is that correct?
Yes, Your Honor, that's correct.
Okay. So why do we need to be so specific? It feels like the Summit County Jail is providing all the protections you need to figure out what's being said.
Had a lot of time after the inspection to stay, which is part of housing somebody. I appreciate that. And that
Prosecuting them, yeah.
and that risk that we're missing.
All right. Okay, I understand your position. Thank you.
Thank you, sir.
You'll get the last word.
Yes, sir.
I'm sorry, Ms. Lazaro, is this one
Thank you.
first?
Yes.
Just level with me. Do you think there's any part of this motion that I should grant?
No.
Okay. All right, is there anything else you want to say about it?
I think it should be denied, and I think that, I'm just gonna reiterate, the problem is the entire thing is premised on their accusation of witness tampering, which they have failed to prove.
Well,
I mean,
perhaps we can acknowledge that there are several plausible readings of the walk the dog letter.
yeah, if the court wants to.
One of the several plausible ones would be consistent with the state's version.
Correct.
Okay,
And one would be the defense's
agreed.
version, and.
I guess what I'm saying is,
if the
why do
court
I have
wants
to
to go
figure it
for-
out?
Well, you don't, and that's the problem, we shouldn't
Okay.
have to. Like, that's the whole problem with all of this, is they're alleging a crime without any sort of due process, or without any sort of evidence to support it. And the fact that letter,
There's some evidence, I mean, their letter exists.
a letter exists, yes, but there's no indication in the reading of that letter that that letter could be written in the lens of these are the people who are going to testify. I want them to remember these things, right? And that wouldn't be witness tampering. She can completely do that. Also, that letter was never passed or showed, and the inferences made by the state is just because she held up one letter that she must have was going to do it with this one, and that's the problem. Like, they have not made a showing that even comes close to a probable cause finding for witness tampering. And, I think there needs to be some acknowledgement, if the court's inclined to deny that there isn't a finding that happened as part of it.
I think it's probably more important for me to make no finding whatsoever on that, isn't there?
Yeah.
Okay. I understand your position. Mr. Blood, relief, further.
No, yeah.
All right. Issue before the court is the state's motion for no contact order that seeks an order preventing defendant from having any contact with your mother or brother to prevent further tampering with testimony. The state has narrowed the relief it requests today at oral argument to say that defendant should have all in-person, or request that defendant have all in-person meetings with their mother or brother with counsel present, and that other communications be monitored in specific ways through technology available at the jail. First, the defendant has a First Amendment right and to correspond with whom she pleases and to say what she likes, as long as she doesn't do anything that requires a prior restraint justified by a sufficiently strong interest that countervails her First Amendment rights. Here, there's no evidence that she's done any such thing that requires her to be prohibited from speaking to any specific human being. The Walk the Dog letters have several plausible readings. It does not include any threats whatsoever or any other kind of communication that would typically justify a prior restraint on free speech. Moreover, there's no evidence that it was ever handed to anyone. And the state hasn't. So to the extent they need to cross-examine a witness or impeach a witness with its contents at trial, they would be able to do so absent some other ruling by the court excluding the letter or suppressing the search that found it. Moreover, the status quo is that defendant's communications with everyone except her lawyer are monitored. They're recorded. And the court's in no position to make that job easier for the state. So the court is simply not presented with a sufficient basis to restrain Ms. Richins' First Amendment rights. The motion for no contact order is respectfully denied. Okay, anything further there, Mr. Blower?
No.
Ms. Lazaro? Okay. All right, Ms. Lazaro, the motion to enforce order for contempt sanctions, if I sufficiently addressed that in reaching the conclusion on the motion for prosecutorial misconduct?
Yes.
Okay. The court is hereby denying the defendant's motion to enforce order and for contempt sanctions based on the same reasoning that justified the denial of the motion for dismissal based upon prosecutorial misconduct. Let's turn next to the state's motion to compel good cause disclosures. Ms. Lazaro, can I start with your team on this?
Sure.
Is it you?
Well, I guess until I need a lawyer, it is.
There's a 60-page document. I have no idea what's in it. You claim you assert it's privileged, correct?
I don't, there is a folder, or a manila envelope that Ms. Richins kept in her cell.
Right.
That contains a lot of pieces of paper.
Okay.
Okay. As far as whether a document, our assertion, yes, is that everything contained in that is privileged by way of It was given to me, it wasn't given to anybody else, it wasn't published, nothing else was done with it. So yes, that's our assertion.
So the defense asserts this 60-page or 60-something page document is privileged. The state asserts it is not and is material to their case because, depending on which version of the explanation you focus on, it reflects a partial factual, partial fictional narrative. Typically, what we do is in-camera review and then allow the parties to make arguments regarding the content of the document and have a legal ruling about whether it is in fact privileged and subject to disclosure if it's not. You have access to the documents, so you're in a good place to make those arguments. I can't ask the state to argue about this with one hand tied behind their back. So, do we give the review attorney access to the document with a strict order that the review attorney cannot share any of the substance of the document, certainly not the document itself, with anyone from the state, and then have a sealed proceeding by which your team represents defendant's interests on this issue, the review attorney represents the state's interests, and then I make a determination.
We could do that, or the court could do an in-camera review. We, as a team, kind of reviewed and discussed this. This kind of came up last minute, as far as putting it on today. And I guess I'll put this question to the court. Part as to how you want to go forward on it. Part of our, I think, concern or things we want to address as it relates to privilege is how and where it was found. And if the court is just simply inquiring as to the contents of the packet itself.
Well, but would you acknowledge that just putting a document in an envelope labeled attorney-client privilege and handing it to your attorney and no one else, that's not sufficient. If you put a takeout menu in that envelope and hand it to your attorney, the takeout menu is not an attorney-client privilege communication.
That's correct, it wouldn't be, but this isn't a takeout menu, these are her handwritten notes.
I know, but I don't know what they say. So if they are in fact a fictional narrative where she's just writing a short story, I'm not sure they're privileged at all.
Well, I think.
But I'm also not sure the materials. I
was gonna say, I think it needs, before anything, whether it's reviewed by the court in camera or whether it's reviewed by Mr. Jordan, I think there needs to be a twofold analysis as to what and what not is privileged, and then what and what not may or may not be relevant before it's turned over to the state for review.
I agree. What I am reluctant to do is make that determination in a vacuum without the benefit of advocacy by the defense and the state. And so I agree with you, though. It's a two-part determination. And the privilege issue is a gate. If I determine that it's a privileged communication, it does not get produced, no matter how material it is. All right, let me ask the state about this. Mr. Bloodworth, you see where I'm headed here procedurally. Any objection?
No, Your Honor, that's what the state asked.
It was unclear to me, though, whether you were asking for the review attorney to just make the call or have only the review attorney brief it. But what would need to be clear is the review attorney would have access to this, would be the state's agent, would represent the state's interests, but none of your team and none of your office, nobody else in the executive branch could have access to the document or disclosure of its contents. And so that made the ruling.
Your Honor, I'd back off a little bit of what she said and say it's that the review attorney is not the state's agent, he's a neutral. He was selected by the defense.
Not in my proposal. My proposal is the review attorney represents the state on this issue. Because Ms. Lazaro and her team are going to be making advocacy arguments on behalf of the defendant that I imagine go in the opposite direction.
Well, Your Honor, I imagine the state too would present advocacy on its behalf, at least to the threshold matter of privilege.
How? You won't know what's in the document. So you need a lawyer that has access to it. And it can't be for the litigation.
No, Your Honor, to some degree, the state does know what's in the document because the state has listened to jail calls where the defendant describes in great detail what's in the document. And that is
Maybe, but we have no idea if that description is accurate or not. The document speaks for itself.
correct, Your Honor, but how the review attorney interprets the document will depend on some measure in the defendant's characterization of it. So the state
Fair enough, and so will the defense have to navigate those waters.
Yes, Your Honor. The state envisioned and asked for a procedure with the review attorney or the court. We asked for it in the alternative, whereby both the state and defense can present a legal argument based on whatever facts they know as to whether or not particular material inside the envelope is privileged. So then he can make a threshold determination on privilege. And then, once we're past that, there may be material determination on it.
It's not the way this usually works. Candidly, we're describing hamstrings on both sides. I'm not even sure it would be reviewable if we did it that way. Why wouldn't we just have the state designate, I imagine it would be outside counsel, for this specific task and walled off from the state's prosecution team? When I represented members of the media, this is how we did it. Right, like I can't share any of this information with the reporter, but I can argue why they should have access to it based upon the content of the document. Where do you see the error here?
Your Honor, the state's agreeable to her, pursuing it in the fashion the court described. I've seen it work both ways. I think that the way you described is perhaps more common in civil litigation context than criminal one.
Sure.
And I'm fine to proceed, the state is fine to proceed in either fashion. The state's, the thrust of the state's argument is material needs to be reviewed by a neutral. The defense alone cannot make a privilege determination.
I don't disagree.
And whatever procedure the court prefers to accomplish that, the state needs to.
Okay, I appreciate that. Have a seat. There's a lot of chatter over there, Ms. Lazaro.
Sorry.
You feel like we need to
Yeah,
go in a different direction?
just, I guess, 2 points I'd like to make. Given that the court is viewing the review attorney as an arm of the state, our preference would be that the contents be reviewed in camera, or at least the initial.
Maybe I'm wrong about that. Forgive me. I mean, the existence of the review attorney,
Generally speaking.
their identity was new to me until I read the briefing on this issue, right? And so it doesn't have to be the review attorney, but what I'm trying to avoid is, on the one hand, the court making this determination without the benefit of the adversarial process.
And we're not asking for that. I agree with the court's proposition as to how to move forward. And that it first get reviewed for privilege, and then we address materiality of it. I don't think, when we're talking about the first step and the privilege, if we're arguing about whether or not certain things contained in there are privileged or aren't privileged, the state, it's the counsel here today, should not be able to make those arguments because it negates the whole point of privilege.
That's my point.
Okay.
And so that's why I think they, in my version of the procedure, need to have an outside lawyer whose sole role is to make those arguments on behalf of the state.
Right. And we have identified Mr. Jordan as
That,
an agreed upon review attorney
okay.
as it relates to that. So I guess I'm envisioning probably 2 separate processes. We'd have a hearing on, or at least briefing on privilege and then briefing on materiality.
Yeah, maybe we can just do it all at once. I don't know.
Well, I guess, yes. Well,
If you're gonna review
Yes,
the documents,
that's
right,
fine.
reading this.
that's fine. The other thing I just think is an important, like a side note, and this is probably gonna come up in the briefing. The jail searched that packet multiple times and passed on everything in it. It was, and I'm just bringing that up as, and like I said, it'll probably come up in argument, but, you know, they've already, you know, they have been through it. So,
I'm not sure what the significance of that is, but I don't know that I need to.
Yeah, we don't need to get into it today.
Okay. All right, so,
can I have questions?
no, I have some practical questions for the state. And if you're not prepared to answer them right now, Mr. Bloodworth, I understand. I'm just moving this issue in a direction maybe you didn't anticipate, but are you prepared to stipulate that the review attorney, Mr. Jordan, will be the state's attorney for the purposes of this walled-off review of the 60 whatever page document? Or do you want to designate a different lawyer and keep the review attorney separated for future tasks? Maybe not.
Your Honor, I want to consult with my team briefly on this, and part of the reason why is the review attorney is already engaged on other reviews.
Right, okay,
And so my sense is we need a new attorney,
maybe so.
that I don't want any of his other reviews to
Be affected.
be affected.
Okay. Why don't we're on for about 90 minutes. Why don't we take a 15-minute break?
Before we get there,
yeah.
can I just make one more point?
Sure.
I think before we get to the point of whether or not they're privileged or not privileged, we need to address whether or not we should be compelled to turn it over to start with.
That would depend upon materiality, right?
Okay.
I think that's right.
I mean, I think the state needs to make a showing as to why they think they get this packet, first of
No,
all,
I-
right?
Well, all right, so let's put aside any issues of whether the way the document came to the state's attention is appropriate, should be suppressed, excluded. Put that aside. I don't have any motion like that in front of me.
Okay,
The state knows about it. They know some things that Ms. Richins has said that they think refer to the content of the document. Don't know whether or not they're accurate, we'll find out. Whether the defendant has to turn it over under Rule 16 will depend upon whether it's material, right? Whether there's good cause for disclosure. Hypothetically, if she's like, here is a timeline of how this went down, and just gives a list of admissions, and somehow it's not privileged, right, that's the kind of thing that would need to be handed over. If it's, here is a short story about Care Bears, I'm not sure it's the kind of thing that needs to be handed over.
I
Do you
think,
see the law differently?
well, I guess in my mind, we need to go back a step. I mean, we're talking about whether or not things are privileged or not privileged, and then if they aren't privileged, whether they're material. Before we get to that, I think the state needs to provide a good cause showing as to why they think they get it, and I think it doesn't, before we ever get to any of those steps, like,
Well, I
Why?
think they would say they have a sufficient threshold to trigger the privilege review based upon portions of the recordings of Ms. Richins' jail calls in which she says this is part fictional, part factual. Am I summarizing that correctly, Mr. Bloodworth?
Yes, Your Honor, 100%.
And so there's a reasonable inference in the state's view that the parts that are factual are backward-looking statements about what happened. They're factual. We'll find out. But there's at least enough that the state has presented to trigger your need to assert the privilege, maybe move to suppress, I don't know, and then to trigger the related materiality. You see it differently?
that's fine.
Take a recess.
Why don't we take
Take a recess.
Yeah. we can
Okay,
use that.
sounds good. Listen, there's a lot of people in here, so if you need to get up and move around, that's fine, but it's 15 minutes. So if you don't want to get locked out, consider staying put. We'll be back at 3:20. Thank you very much. See Rule 16C and tell me if you see it the same way.
Okay.
So, initially, the only thing the state has to show is the materiality of the information requested from the defense before the defense is required to either make the information available or assert a constitutional privilege, such as one against self-incrimination, an evidentiary privilege, such as the attorney-client privilege, or a counter-argument that you're wrong, it's not material. Why aren't we at that point where you're saying, for example, it's privileged, maybe additional privileges and arguments will be raised in the briefing that would occur behind seals, such as what they want would implicate Ms. Richins' right against self-incrimination and or it's not material. That's what I'm trying to have play out through the adversarial process, and I don't know what's in the document.
Right, I think perhaps the state needs to make a good cause showing that they're entitled to it, I think, before we get to whether the materiality of it.
I think that's where we differ, and the reason I say so is, and I'm happy to be educated about this, but State v. Spry, 2001, UT App 75. We further hold that the good cause, quote unquote, under Rule 16C requires the prosecution to establish only the materiality of the information requested from the defense before the defense is required to make such information available to the prosecution. But also that things like the right to be privileged against self-incrimination is paramount and therefore overcomes that good cause consideration. The state in its motion is saying, we think there's good cause here because based upon our interpretation of the content of the jail calls, this is a factual, partially factual narrative. Therefore, it's here. I don't know if that's true.
And if that's the court's position, they've only made that as it relates to the 60 pages, not the entire packet.
I agree.
So
Are we talking about the entire packet?
well, it was unclear to me.
Mr. Nate says yes.
Yes, I was asked to turn over the entire packet.
Is that accurate, Mr. Bloodworth? I thought the briefing was I agreed to turn over the 60-page document, and then upon reflection, I
And
can't
then
do that anymore.
it was further requested that I give the packet to the review attorney. And the problem,
Did I
with
just
that-
call Mr. Nate?
It's okay, you're up.
I
the
apologize.
problem- the problem with that is I can't, once I assert a privilege, I can't turn it over or I waive the privilege,
Understood.
and I can't turn over a part of it. So I guess what I need from the court today is an order telling me I need to turn over the 60 pages. If that's
No.
what the court's inclined to do.
No, I'm inclined to not do that.
Well,
So
am I, do I
Let's
get it?
take a step
Okay.
back. I understood, Mr. Bloodworth, that we were talking about the document, not the folder.
Your Honor, there's letter number 2,
So that's what she held up.
which is the one she held up,
Okay.
and then 60 or so pages of what she describes as the continuation of the walk the dog fictional narrative.
Okay. All right, those are the two documents we're talking about.
Yes, Your Honor. We don't know what else is in there to make a good cause showing.
Well, that's the way it goes, though, when people are handing an attorney-client privilege or a marked folder to their attorney.
Well, yes, Your Honor, but when removal of the material from the jail violates jail policy, that adds another wrinkle to it.
Let's stay focused on the two
Yeah.
documents. I don't have enough to speculate about what may have been or not in that folder, and now I understand the significance of Ms. Lazaro telling me jail staff went through the folder several times. Now, I understand where you were headed with that. Let's stay focused on just the two documents, the one page that was held up, which the vernacular for that is letter number 2.
The vernacular is letter number 2, Your Honor. It was multiple pages.
Okay. And then the 60-ish page document.
Correct.
Why shouldn't we handle those 2 documents in the way the court proposes?
I have no objection to that, provided that the court order me to give them to the review attorney or the court. I have no objection to those 2 documents.
We're
So
going
long
to put an
as-
order in place first, identify who either the review attorney or the shielded representative of the state in this process is. And I understand that normally the court would just review a document and make a determination about privilege. This case is very high stakes. It's an aggravated felony. It has enormous amounts of attention. I don't want to make this decision without the benefit of the adversarial process. So we're going to use belt and suspenders on this one. Have you determined, Mr. Bloodworth, who is going to represent the state in this process?
Your Honor, not by name.
Okay.
We can, but the state will select somebody at short order to serve as the state's advocate in this process.
I appreciate that. What I'm inclined to do is order counsel to meet, confer regarding the terms of an order that will control how this process unfolds. It states in black and white who is allowed to have access and not allowed to have access to the 60-page document and letter number 2, and then hopefully provide some deadlines for submitting the 2 documents to the state's shielded attorney and briefing deadlines for getting it before the court. Does that sound reasonable, Ms. Listener?
Yes.
Mr. Bloodworth?
Yes, Your Honor.
That is the state's order. Can you meet, confer on that within 1 week?
I am, yes.
Or
Is
no?
that- Probably not, actually.
Okay.
I'm gone. I'm going to be out of town working the majority of next week, and I'm on vacation the following.
How much time would you like to get this sorted out?
Can we go to maybe the beginning of December?
By December 1, I need a proposed formal order or competing proposed formal order submitted to the court.
And just so I'm clear today, the court's ordering me to,
Not disclose anything yet
until you have this
until
proposal.
the rules of this review are set, the participants are identified, those that cannot participate are identified, and that order's in place.
Okay.
Then everybody will know what they can and can't do.
I understand.
I think that's the appropriate way to handle this. Any objection, Mr. Bloodworth?
No, Your Honor.
Okay. All right. That handles for today. The motion for motion to compel good cause disclosures. To be clear, I'm not expressing any opinion one way or the other about what's in this document, whether it's material, beyond the prima facie showing of good cause, or whether any other privilege would apply to it. I just don't know what's in it, and I need better briefing regarding the circumstances under which it was created, who it was provided to, things like that. Okay. I think, Ms. Lazaro, Mr. Bloodworth, that brings us to conclusion on the motions that are pending in the criminal matter. Is that correct?
Yes.
Okay. Mr. Bloodworth?
Yes, Your Honor, to the extent the motion to compel is concluded
Well, it's concluded for
for
today.
today.
All right, very good. Let's turn next to the probate case.
Switch spots. Your Honor, perhaps before that, can we discuss scheduling of this matter? I think that was part of today's initial agenda.
Yes, that makes sense. I can appreciate why you wouldn't be comfortable having this matter not have a next scheduling conference, but there's a lot to be worked out on some document discovery issues. Ms. Lazaro, what do you propose?
I think my proposal would be, let's get this order in place with the timelines and then schedule dates accordingly at that time.
I'm comfortable with that, Mr. Bloodworth, if you are.
Yes, Your Honor. We want them to get something on the calendar, perhaps mid-December.
Well, I think part of the court's order was that in our proposed order, we come up with deadlines and then
For briefing,
For
that'll
briefing.
drive
that'll drive the next hearing.
my consideration, and then there will be a sealed hearing, I imagine, to hear from counsel's argument and you make a ruling.
Okay, Your Honor, then we can perhaps
Yeah.
confirm and propose as part of that.
That would be my
scheduling
preference. Yeah.
Yeah.
Yes, Your Honor.
But that works.
Anything else?
We don't, Lisa, let me go around that. No, sir, thank you.
Okay. All right, very good.